Well, I've really stirred a hornet's nest with my last few TV licensing videos, and in this video, how you might be able to stop these letters once and for all. Whilst this cannot be taken as legal advice, if I wanted a really robust approach to absolutely stop these letters, else they might really be liable in harassment, I'll tell you and guide you as to what I would do. And I'll also answer some questions and correct some sort of misconceptions that people have had about how this works. Run through a bit of the law and the definitions and a bit of an experience I had when I contacted the press office to say, you really need to answer this question. More about that all a little bit later. Please do bear with me. I'm struggling with the old throat, but that's never stopped me yet. No excuses. We carry on. And do subscribe to the channel if you like this approach. I'll be very grateful. We're not far off 1 million subscribers now. We're getting there. Together, we're getting there. Now, in no particular order, I did receive an email, and I respect the view. I don't agree with the view, but I respect the view that someone said these letters are not menacing and unreasonable. It's more just a sales pitch. They're trying to get you to buy their service. Now, respectfully, I disagree for two reasons. In reverse order, it's not a service that you're buying from them. It's not a product or a service from TV licensing. It is a license, which you must have if you watch or record live TV or consume BBC content on BBC iPlayer. There's an interesting quirk about that because the word iPlayer is not actually mentioned in the legislation or the regulations. It refers to an on-demand service provided by the BBC, which is going to come back to in a minute with regard to the YouTube stuff. But it is not a product or a service. It's a license, which you must have if you do those things or you've installed something for that purpose, which is, again, it's a little bit complicated. Another question I had is someone, and I'll bring it on screen here, not the question, but really where the answer to the question comes from. Someone said that they cancelled their license and they told that they were going to get a month refund plus another round about £75. And they asked, surely that means, they're taking out some kind of credit or they're front loading and all of that sort of stuff. And it's misleading and unclear and doesn't seem fair. Now, it might not seem fair and it might seem unreasonable, but with respect, it's actually quite clear if you do read and find and read this page here, where I don't really know why this is, but it says, because of the law, you must pay for your first license upfront in the first 6 months. So this means you pay the first 6 installments at a higher rate at £29.10 a month. And then from month 7 onwards, you pay £14.54. And so, obviously you pay for the whole license over the 12 months. It's not credit as such because you're paying up front for something. So it's not giving you credit. It's not like you have the thing now and you pay later, which is what credit would be. And in any event, it wouldn't be a regulated credit agreement because a regulated credit agreement would be that where you're paying in more than 12 installments or for more than 12 months, or they attach fees and interest and so on. Interesting trivia on that point. I held a company accountable for doing exactly this with one of my clients. They were providing effectively a credit agreement to the client and they were not regulated to do so. So my obvious response to them was, well, you're breaking the law here, so you better refund the client because this might get you in more trouble. Boom, very quickly got the money refunded because they didn't want to get prosecuted for it. Interesting quirk aside. Now, let's take a look at what we're actually talking about here, because the offence for the TV licensing, and I'll come around to how you can stop the letters in a moment, but the offence for TV licensing is under the Communications Act of 2003. This is where we play the legislation hop, as I call it. We hop around the legislation to find out what it really means. And I've just realized you can't quite see that on the screen properly. Let me move that across a little bit so you can see it better. So the license is required. A TV receiver must not be installed or used unless the installation and use of the receiver, which we'll come back to in a minute, is authorized by a license. So you must have a license if you either install or use a television receiver. So then you think, right, well, what is a television receiver? I'm going to come back to my conversation with TV licensing office because that was interesting in and of itself. What is a television receiver? Because all this talk of their programs going on YouTube is like got people thinking, hang on a minute, is that now a TV receiver of some sort? Well, the meaning of a television receiver is not in the Communications Act. It's in the Communications Television Licensing Regulations of 2004. In Regulation 9, to be specific, where it says meaning of television receiver, it means any apparatus installed or used for the purpose of receiving, whether by means of wireless telegraphy or otherwise, any television program service or an on-demand service program which is provided by the BBC. Now, two things there. In order this time. Firstly, we have a new definition, a television program service, which is received on a television receiver. And secondly, we have, which I'll come back to in a minute, and we also have an on-demand program service provided by the BBC. Then we go to the question of, well, surely if the BBC is now going to provide programs on YouTube, doesn't that bring it within this sort of iPlayer thing? Well, no. And the second question is, someone said, well, surely you have to download and use iPlayer rather than watch the BBC video on the BBC website. And the answer to that is also no, because it's still provided by the BBC. If it's an on-demand program service provided by the BBC on their website, as well as iPlayer, then obviously that's going to fall into the same category. But YouTube, no, because the BBC do not provide that service unless, which I very much doubt would ever happen, unless Google carved out some kind of agreement whereby the BBC was providing that service on behalf of Google/YouTube. But then what's the point? They do it themselves. So no, that's just not the case. So this says a service provided, an on-demand service provided by the BBC. Now, to be clear, the on-demand is not live. And live is defined somewhere else, is where it's broadcast to the general public that receive it at or virtually around at the same time. Now, as you know, being a barrister involves a huge amount of reading, writing, and research. The Companies Act alone has 1,337 pages of text. You also know over the last few weeks or so, I've been researching AI tools to produce really helpful guides for you. So to that end, I've found Skywork, who now supports and sponsors this channel here. With Skywork, I can upload a huge piece of legislation or a lengthy judgment such as this one in For Women Scotland. It will summarize it and produce a neat structure of easily digestible sections, or a presentation such as a professional looking PowerPoint presentation. It can even create timelines and the key questions, and in this case the conclusions the court came to. Skywork professional data can connect to authoritative sources, and unlike other tools like I've criticized in recent videos, this will significantly reduce any hallucinations, made up garbage, so that it won't confuse the information that it gives you, so it can generate verified, accurate, and reliable information. What surprised me the most, I must admit, is that Skywork can even produce an audio version of these summaries. So you can produce these summaries so that you can listen to them whilst you're out and about, driving, walking, or jogging, making the very best use of your time. Now, for someone like me who is integrating valuable content to you in these videos and on my website, Skywork is a valuable tool. Of course, they are sponsoring my channel here to be completely transparent, but it is going to make my life so much easier to summarize this information and present it to you. So check out Skywork. I think you'll find it incredibly useful, which is what we get in Subregulation 9.3, where it says, in this regulation, any reference to receiving a television program service includes a reference to receiving by any means any program included in that service where the program is received at the same time or virtually the same time as it is received by members of the public by virtue of it being broadcast or distributed as part of that service. So live, in other words, or nearly live. So this answers the question. People say, well, what if I pause it for a few minutes? Is that then no longer live? Well, it's a fine line, and that's not really defined. That would be a question of fact for a court to determine if you were prosecuted, and you would have to show that you were not receiving it at or virtually at the same time as everyone else. Now, the confusion, there's two confusion people get, is one is pausing it, and secondly, the catch-up, broadcast 1 hour later shows. That is still live, because just because it's broadcast an hour later doesn't mean it's not live anymore. But pausing it, well, it will be for a court to determine. If you paused it for 5 minutes, 15 minutes, that would still be virtually the same time as everyone else, because you're just a bit delayed. If you paused it and came back 3 days later, there's a strong argument that it's no longer live, in my view. Not that this is legal advice, but there we are. But we come back to definitions. So we've got meaning of a television receiver is that by which you receive any television program service. Now, what on earth is a television program service? Well, we come back to the Communications Act, funnily enough, of 2003. And we jump down, first of all, to the television program service bit here, which says any of the following: a television broadcast service, a television licensable content service, a digital television program service, or a restricted television service. And so one of those could be a broadcasting service. So if it's broadcast and it's taken to mean at around the same time, so it's not licensable, it's not anything else that's restricted, it is just a broadcast received at the same time per the other regulation. So then a broadcasting service means, subject to subsection 4, a service which consists of a television program provided with a view to being broadcast, whether in digital or analog, is provided to be available for reception by members of the public and is not a restricted or one of these other type of services. And so therefore, it's obvious just something that is broadcast and intended to be available to members of the public at the same time. So what does that mean? Well, there's a definition for that as well in, funnily enough, again, in the Communications Act of 2003. Section 361, meaning of available for reception by members of the public. The services that are taken to be for the purposes of this part 3, to be available for reception by members of the public include, subject to subsection 2, which I'll come back to, any service which A, is made available for reception, or is made available for reception in an intelligible form only to persons who subscribe to the service, whether for paid or particular occasion, or who otherwise requests its provision. So this bit includes those where you've paid to watch a live program. That's a bit of an anomaly, which a lot of people fall foul of, because let's say a big fighting match or something, and you pay to watch it, but it's live. You're paying for it, and you need to pay for the TV license to watch it. So it's a bit of a double whammy, and people don't tend to like it. Or B is a service, the facility of subscribing to which or of otherwise requesting provision is offered or made available to members of the public. So just broadcast in any means whatsoever. So this includes everything worldwide. Subsection 2, which is the exception, a service is not to be treated as available for reception by members of the public if it is an on-demand program service. So you go on, you watch it. It's not live, you're watching it. So think Netflix, but not live Netflix, by way of example. Or a non-UK on-demand program service that is a tier 1 service. So again, it's not live. Now, the next question is, people ask, well, can't they just change this law on a whim because this provides that they can make these changes? Well, under sub 7, the Secretary of State may, by order, modify any of the provisions in this section if it appears appropriate, etc. But no order under sub 8, no order shall be made containing the provision authorised by sub 7 unless a draft order has been laid before Parliament and approved by a resolution of each House. So each of the Houses of Parliament. So it needs to go through Parliament for any of this to be changed. So now, what powers does TV licensing actually have to enforce the TV license? Well, it is a little bit more limited than a lot of people seem to think it is, mainly because people get bombarded with letter after letter after letter and visits, as they say. They do thousands of visits every single day. But is that statutory enforcement of the TV license? And if not, what is? Well, as a matter of fact, in most cases, the letters and the visits are not statutory enforcement of the TV license. The exception, of course, is the warrant, and that is set out under section 366. And I will, I promise, come back to how you stop those letters in a moment. But this bit warrants explanation first. Section 366 talks about warrants, the power to enforce TV licensing. This is also why it's not a service that they're selling you. This is something that they can enforce. But it's a lot more restrictive than a lot of people seem to realize. And there are a few sort of pitfalls that people might trip over which allow them to obtain a warrant, whereas otherwise they might not do. Let's break this down. A justice of the peace or a sheriff in Scotland or a lay magistrate in Northern Ireland must be satisfied by information on oath by the TV licensing guys that there are reasonable grounds for believing, which is not a particularly high bar, but there must be some evidence to produce reasonable grounds for believing that A, an offence under 363 has been or is being committed, i.e. you're watching or recording live TV or watching iPlayer without a licence. B, that evidence on the commission of the offence is likely to be on the premises, so they can come in and find evidence that you've been doing that sort of thing. C, that one or more of the conditions set out in 3 is satisfied, and that's the bit that we need to come back to. Then they may grant a warrant, and the warrant means that they can enter the premises and search and examine and test any television receiver found there. And as it happens, you are under a duty to provide reasonable assistance if they do so. But let's not focus on that. Let's focus on the conditions to be satisfied first. Without one of these, they will not get a warrant. And this is going to play into my how to not have them visit anymore thing. It's no guarantee, but it's what I would do if I wanted a robust approach to stop the letters and stop the visits. Absent a warrant, obviously. These conditions, one of which at least they must satisfy. It's a bit like obtaining an injunction. You only have to have one of the things satisfied and you get it. Or it's like an appeal. You can have 10 grounds of appeal, but if one of them is satisfied, you get your appeal, because on any one of them, that would satisfy the court that you should have your appeal, you should have your injunction, or in this case, you should get the warrant, or they should get the warrant. So these conditions are, in the alternative, A, that no person entitled to grant entry to the premises or vehicle with whom it's practicable to communicate. In other words, there's no one there that they can really talk to. B, that there's no person entitled to grant access to the evidence with whom it's practicable to communicate. In other words, there's no one there that's going to allow them to look at the TV stuff, or if there is TV stuff, or TV receiving stuff, you know? C, the entry to the premises or vehicle will not be granted unless a warrant is produced. Now, it's normally, I think, this one, C, that they use in conjunction with some kind of evidence, which I'll come back to in a minute. There's a lot to come back to, I know. This is law. I think it's C combined with some kind of evidence that gives them a reasonable grounds to believe that you're committing the TV licensing offence that gets them the warrant. Now, why do I think that this is the combination? Well, entry to the premises or vehicle will not be granted. So you've just stopped them at the door, you don't let them in, you've refused to let them in a number of times and so on. But they have some evidence that you might be watching or recording it. This is usually obtained, as I understand it, from both people that used to work for TV licensing that have emailed me, and people that have had these communications and been prosecuted, and from my general experience, knowledge, and research. These are the general reasons I think people end up having a warrant issued against their address for search under this section. As follows. Conversation at the door. They let something slip that they only watch this or they only watch that, and that could be construed as being live TV. Or TV is overheard, or it is seen through the door, or it's seen through the window, which might be challengeable by itself, because why would they be looking through a window? I'd be challenging that. Why are you on the front grass looking through the window when you've only got implied license to come to the front door? Again, see my template to withdraw the implied right of access to walk up to the front door, and then they shouldn't do so. But this video is a stronger approach to that. Another one that I've heard of is they're obtaining IP addresses and login information. They've been writing to people to say, we've got evidence that you've logged into iPlayer and watched stuff. And obviously, that would be stronger evidence that you've committed that offence, particularly if it's registered against your address and things like that. And so all of that, given a reasonable belief that you're committing the offence and you're not likely to let them in using 3C, might get them a warrant. D, that the purpose of the search may be frustrated or seriously prejudiced unless the search is carried out by a person who secures entry immediately on arrival at the premises. So they need the warrant because they need to catch you in the act. That's what D says. So all of that, they can then get a warrant if they satisfy one of those conditions and the reasonable belief that you're committing or have been committing the offence. Now, anything else is therefore not statutory enforcement of the TV licence. Not the letters, not the visits without a warrant. None of them are statutory enforcement. There is nothing in, I've been up and down this act and the regulations, there is nothing in this act that provides a statutory power to write to you, to threaten you with prosecution, to visit you, to check, to interview you, or anything else of that nature, unless it's under the warrant, under enforcement, under this section. This is what provides, what I've just explained, provides the enforcement. They can obtain a warrant under those conditions to come to test equipment, and then you've got a duty to provide reasonable assistance. But if it's not enforcement, why can they do it and why can they get away with it and how can you stop it? Well, the first step is withdrawing the implied right of access to your property, for which I've got a template on my BlackBeltBarrister Pro, which I've linked below, and that removes the implied right of access. Now, there's been various responses to that, to my viewers from TV licensing, and it's a bit of a mixed bag. Sometimes they've just flat out ignored it and told my viewer that they're ignoring it. We don't apply that. We're going to come and check anyway. Sometimes they've said, well, okay, we'll note that down and we won't visit you, but, you know, we will remind you after a year or so, or something of that nature. Now, as I said, there is no statutory power to send you these letters or to visit you to check that you're watching live TV. So what can you do? Well, in addition to removing the implied right of access to your property, I may be inclined to write, to sign, and have witnessed in the appropriate form a statutory declaration that I do not watch or record live TV or consume BBC content on BBC iPlayer, that I have no intention of doing so in the future, and that if I did so, that I would buy a license, and that I have not done so without a license. So why is this important, and why is it different than a normal statement? Well, a statutory declaration is something that you make with absolute belief in the truth. Because if you lie or you are careless with the truth in a statutory declaration, that would be perjury and it's a criminal offence. So it is useful in many situations. For example, if you are convicted of a motoring offence and you were not aware of the proceedings, there's a special rule in the criminal procedure rules where if within 21 days you make a statutory declaration that you were ignorant of the proceedings, then it's not at the magistrate's discretion to take the truth of your statutory declaration. In fact, Rule 2417 of the Criminal Procedure Rules provides that if you make a statutory declaration of ignorance of the proceedings and it's within 21 days and the case began with a summons or requisition, then the court must treat the summons or requisition and all subsequent proceedings as void, but not the information written in that it began with. So if you make a statutory declaration to the court within that requisite timeframe, the court is bound to accept the truth unless proven otherwise. So if you made a statutory declaration that you do not watch or record live TV and couple that with a request not to contact you any further, they would really justifiably need evidence, further evidence that you're watching or recording live TV to keep sending you letters or to visit you. And so by making a formal statutory declaration, you are making one of the strongest confirmations of truth without going to court and having a declaration or a finding of fact made by the court. Think execution of deeds that are required to be proved without going to court. They are properly proved by a statutory declaration. They are used in a variety of situations such as revenue collection, deed poll, changing your name, parking ticket appeals, and as I mentioned, challenging a motoring conviction of which you were not aware because you were not aware of the proceedings. So think of a statutory declaration as one of the strongest forms of proof without actually going to court. It is strong and they should accept it. And if they don't accept it, then they need to provide evidence to the contrary. So if you were to provide a statutory declaration to that effect that you don't watch or record live TV, you have no intention of doing so, and you haven't done so without a license, then also couple that with a letter to say, please cease and desist sending me letters or visiting my property. And you can couple that with the removal of the implied right of access to visit your property. And with all three, they should not write to you and they should not visit you. If they do, that would make a fairly strong and robust case for harassment. Because if the letters cross a threshold that is unreasonable, and they do so after you've made this statutory declaration, so they are in possession of a sworn statement that you do not do those things, they would have to justify contacting you again. And that also kicks in the data protection principles, because on the one hand, they can deal with your data because there's a legitimate interest in doing so to write to you about the TV license fee. If they continue to send you letters after you've sent them a statutory declaration and a cease and desist letter and withdrawing the implied right of access, and they continue to process your data in that way, they may then be in breach of the Data Protection Act and GDPR, the UK retained version thereof. Now, they will still say, well, we can do that because, we're administering the license fee and therefore it's a legitimate interest and so on. But the argument, the complaint, if you will, would be that you've made this declaration that you do not require a license. Therefore, stop contacting me. So as I said, this is not legal advice. This is just something I might be minded to do if I got really annoyed that they kept sending me letters when I'd asked them not to. And the final thing I promised I'd come back to, so well done if you're still here, is my email exchange with TV licensing back in 2022. I said, "Dear Press Office, please provide a definitive comment on the following for publication at 2 o'clock today," back then. In your view, is a TV license required to watch YouTube or Twitch live streams by private individuals? non-standard TV companies? And secondly, where is a member of the public able to find a definitive list of companies that do classify as TV companies for the purposes of a license? Initially, they just said, we refer you to the Communications Act 2003 and Regulation 9 of the 2004 regulations. I replied to say, I'm familiar with both of those, but with respect, you've not answered either of my questions, and neither is definitively addressed in the legislation. If TV licensing is in a position to prosecute members of the public, they ought to know, and TV license should publish, the definitive view on both of those things. They said, we'll come back to you. And they did come back. And in short, they said that we expect that content from the majority of independent YouTube creators would not fit the criteria of a television program service. But there are lots of other things taken into account, such as the regularity of the programming, how continuous it is, editorial control, consistency, quality, production, editorial values, whether it's broadcast live and all of these sort of things. So obviously all of that plays in, but for the majority of YouTubers, it does not apply. I hope you found that useful. If you stuck with me all the way through, well done. Please do subscribe to the channel. And as always, thank you for watching.